My name is Esmé Shirlow, and I'm an associate professor at the ANU's College of Law. And together with Kiran, Nasir, Gore from George Washington University Law School, I co-edited the book that has inspired today's event. And for those of you who aren't familiar with that book, it's entitled The Vienna Convention on the Law of Treaties in Investor-State Disputes, History, Evolution and Future. As the editors of this book, Kiran and I are absolutely delighted to have this opportunity to bring into focus several of the themes that inspired the book, including to spotlight the legacy of the ILC's work on the law of treaties, and in particular, the enduring role and significance of the VCLT in investor-state disputes. We're truly honoured and grateful to have the engagement and support of such an esteemed and expert panel to explore these themes today. And it's my particular pleasure to be able to introduce you to our moderator for today's discussion, Lucy Reed. Lucy Reed is now an independent arbitrator with arbitration chambers in New York, having spent her career in international dispute resolution as, among other roles, a lawyer with the US State Department, head of the International Arbitration Group of Freshfields, and director of the Centre for International Law at the National University of Singapore. And as if this is not enough expertise to lead today's discussions, Lucy informs me that she's just finished teaching an intensive course at NUS on investment treaty disputes, where the first reading assignment came from the VCLT. So I'll hand over to Lucy now to introduce each of our other wonderful panelists and to get our discussion of the connections between the ILC, VCLT and international investment law and arbitration underway. Lucy, over to you.
Thank you, Esmé. Thank you all for organizing and for those who are attending. As Esmé said, the inspiration for this webinar is the book, and I will show it to you. Quite an impressive volume. Let me introduce the panelists very briefly so that we can get quickly to the substance. The longer bios are on the ANU webpage for this event. First, Dr. Vilawan Mangklatanakul, recently elected to the UN International Law Commission, is ambassador of Thailand to Austria and Austria, right? All right, and permanent representative of Thailand to the UN and other international organizations in Vienna. During her 25 plus years with the Ministry of Foreign Affairs of Thailand, Ambassador Vilawan has developed expertise in treaty law, international economic law, and has a keen interest in investment law and dispute mechanisms. Professor Sean Murphy is professor of international law at George Washington University in Washington and a former member of the ILC. He began his career at the US Department of State, where we overlapped, where he worked on matters relating to law of the sea, dispute resolution, oceans, and environment. Sean has served as counsel, arbitrator, or ad hoc judge in cases before the ICJ, the Eritrea-Ethiopia Claims Commission, ICSID, the Permanent Court of Arbitration, the International Criminal Court, and ITLOS. He is a former president of the American Society of International Law. And moving around my screen, Professor Martins Paparinskis is professor of public international law at University College London and a current member of the ILC. His publications are, I can attest, regularly cited by domestic courts and international tribunals. He's a member of the PCA, the ICSID panels of arbitrators and conciliators, the OSCE Court of Conciliation and Arbitration, and the UNECE Water Conventions Implementation Committee. And last but not least, Dr. Penelope Ridings practices in the field of public international law, including international trade and investment and dispute settlement. She's also a member of the ILC now. She's currently an honorary professor at the University of Auckland Law School and formerly New Zealand's chief international legal advisor. So you can see that you are in extremely experienced hands this morning, afternoon, or evening. We're going to be proceeding in an in-conversation format as much as is possible on Zoom. So I will be asking rounds of questions on themes from the book to the panelists. My colleagues will aim to limit their answers and comment on each other, and I promise we will save some time at the end for Q&A from those who are participating remotely. So I propose, colleagues, that we start at the heart of the topic, the influence of the Vienna Convention on Law of Treaties, or VCLT, in investor-state disputes. We all know that the VCLT is the Treaty on Treaties. It's influential in numerous fields of international law. And when you look at the book, you'll see that it demonstrates that international investment law and investor-state dispute settlement are not exceptions to this. And in fact, this field is presenting what one can say is a unique, new-ish case study for seeing the Vienna Convention in action. And if you go to the appendix of the book, you'll find references to the Vienna Convention on the Law of Treaties in, and I had to check this number, 350 publicly available procedural orders, decisions, and awards of investor-state arbitral tribunals. So let's start with you, Dr. Ridings, or if I may, Penelope. What does this evolving practice reveal about the importance of the VCLT in investor-state arbitration so far?
Well, thank you very much, Lucy. I want to first thank most sincerely the Australian National University for organising this event, and also the editors of the book, Esmé, Shirlow, and Kiran, Gore, for their scholarship in compiling, editing, and writing various chapters of the book. The appendix in particular is an extremely useful snapshot of the importance of the VCLT to international investment arbitration and how investment tribunals have addressed the rules in the Vienna Convention. So I will raise three areas where the appendix is especially illuminating. So first is the extent to which the VCLT rules of interpretation in Articles 31 and 32 have been cited by tribunals. And these are the tools that, if properly applied, should lead to coherence and consistency of interpretation in investment tribunal decisions. And we all know that this is one of the complaints of the ISDS system. So what has come clear from the appendix? There is an overwhelming support to Articles 31 to 33 as reflective of customary international law. One trend I noticed was the extent to which supplementary means of interpretation set out in Article 32 have assumed importance in investment arbitration decisions, especially the travaux. So in contrast, there's been a very constrained use of subsequent agreements and subsequent practice under Article 31.3 of the Vienna Convention. So most of the tribunal decisions in this area arose from the Esmé decision and its aftermath. The result, to my mind, can be seen as a lack of deference to the views of states on the interpretation of the relevant treaty. And I think that this will have implications for the way in which parties to treaties seek to influence the interpretation of the agreements in future. One thing I found surprising was the way that some tribunals treated prior decisions of courts and tribunals as supplementary means of interpretation under Article 32. Article 38(1)(d) of the Statute of the International Court of Justice on subsidiary means for the determination of rules of international law has in effect been brought into Article 32 of the VCLT. And I found this very interesting and surprising. The second area that's notable in the appendix are the rules in Article 30 on the application of successive treaties relating to the same subject matter. Most of the decisions in this area also arose from the potential conflict between EU law and the Energy Charter Treaty and the EU law and intra-EU bits. The decisions show the emphasis placed by the tribunals on analysing whether the treaties cover the same subject matter. They also showed that tribunals sought to interpret treaties in harmony with one another. And this is a consistent theme, which I think is very interesting, not only in international investment arbitral decisions, but more generally. The third area are the rules for treaty modification, amendment, and termination. In general, the tribunals addressing these issues took a precise approach to the VCLT rules in this area. So, for example, Article 41 and agreements to modify multilateral treaties between certain parties only, the tribunals required that all the elements of Article 41 be fulfilled, including the notification requirement. Similarly, with respect to Article 59 on the termination or suspension of the operation of a treaty implied by a conclusion of a later treaty, the preconditions set out in that article that the treaties must cover the same subject matter and not be incompatible must also be met. So these examples show the importance of the VCLT for past investment tribunal decisions. So what does this mean for the future? It means that states need to be deliberate in their treaty amendment and termination, and this will have implications for the way any results of the UNCITRAL Working Group 3 discussions will need to be implemented. So I will stop there. So thank you very much.
Thank you. And we will be getting, as one could expect, to UNCITRAL Working Group 3 on a number of points. But your answer leads me naturally to a question to Professor Paparinskis, Martins, and I start by noting that in your work, you specifically have said, and I quote, "The case law of investment treaty tribunals is perhaps the most convenient laboratory at the moment for identifying, refining, and contributing to the development of general rules on interpretation by reference to custom," end quote. So what do you think? What does the practice summarize in this book in relation to interpretation of treaties and other topics indicate about investment law and the importance of arbitration dispute resolution for the development of treaty law in other fields of public international law? In other words, what do you predict will come out of this laboratory?
Well, thank you, Lucy, for asking the question and also for the very kind words of introduction. And may I incorporate by reference the kind things that Penny said about the book. It is really a wonderful resource, or I suppose so I would say myself, because the editors asked me to write a short introductory piece, as they are so obviously a big fan of the selection of the authors and the process. And it's also very kind of you to refer to one of my earlier writings. There is, I suppose, a bit of a sense of meeting the slightly Harvard author. An indication that I wrote it a bit of time ago is that I spoke about case law, and I think nowadays I have become a bit suspicious of the terminology that seems to implicate a bit certain peculiar domestic standards. So laboratory, I think I probably meant to say in the sense that what investment arbitration does not have, rather than what it has, is the trapping of institutions that would be capable of transferring institutional memory, which in other judicial settings, might be, for example, permanent secretariats dealing with substantive matters, or political institutions, or permanent judicial institutions. And there is precisely the lack of that in investment arbitration that makes it more likely that one would be speaking more on the generalist matters. To be perfectly honest, I think that my prediction that something interesting might come out specifically regarding customary law has not been, I think, generally carried out very successfully. If anything, if one looks at the last decade, it is rather at the International Court of Justice in Equatorial Guinea and France case, and in the decided and pending Iran-United States cases where that comes out. But if we look, and I think International Law Commission, in a sense, is a nice benchmark for checking what the influence is, we have a bit of a mixed picture. And I think that the interesting question is whether the influence of investment law comes from the, as it were, the richness of life, the peculiarity of real-life hypotheticals that come up, or the quality of reasoning of the tribunals of those matters. And both of those, of course, may be present. Let me suggest three examples. One example comes from the work of the International Law Commission that culminated in 2018 in the conclusions on subsequent agreements and subsequent practice in relation to the interpretation of treaties. And in that setting, the International Law Commission and now Judge Nolte as a special rapporteur referred quite a bit to various decisions. I mean, to be perfectly honest, and I see that there are some students in my class, the decisions cited are not necessarily those that I would have introduced in the classroom discussion as examples of solid and impressive legal reasoning. So I'm perhaps slightly more inclined to view that as going to the peculiar dynamic of interpretation versus third-party non-state actor that we do not get elsewhere. Another example is the more recent project concluded in 2021 on guidelines to provision application of treaties. So there in the bibliography, we have a great deal of stuff on the UCOS case and associated arbitration procedures. Nothing of that made it into the commentaries themselves. And reading through the discussion of the members, it seems that the general gist was that this was too peculiar to throw light on the generalist considerations. So overall, I have to say there has been some contribution, probably more on the side of throwing up unusual hypotheticals rather than necessarily pushing the quality of the argument. But it could be worse. And so I think that a nice contrast with Judge Nolte's work comes in Sir Michael's parallel project on customary law, where zero investment arbitration awards are cited. So it could always be worse. Thank you.
I want to ask you if you think that when, and I don't say if, there is an international investment tribunal, whether Europe-wise or broader, so more infrastructure, do you think your answer might change?
I mean, I think it must change. I think, as we know, probably from all institutional permanent tribunals, the simple permanence changes the dynamic. If it is not just three people coming together and, as it were, departing and the tribunal becoming functus officio, the dynamic becomes a different one. Considerations of legitimacy on the one hand, perspective of the addressees that find consistent approach helpful, and development of specialized vocabulary move practice, I think, further and further from the generalist source. It's not necessarily a bad thing or a good thing. That is how international law works. But I think that is, what I was coming from in suggesting that if there's one place in international law where I would expect less of that and more of a generalist influence, this is that place.
Thank you. So, Ambassador Vilawan, we're talking about another kind of fragmentation here, other than the ad hoc results from investor state tribunals, but there's a lot of focus on fragmentation in international law, and Exhibit A, I would say, might be the ILC study group 2006 report on fragmentation, which will be well known to this audience, which considers things like lex specialis, special regimes, interpretation of treaties under Article 31, 3C, looking at the relations between the parties, and the application of successive treaties relating to the same subject matter. So I have for you one, maybe two questions. First, from your perspective, what role, if any, has the Vienna Convention on the Law of Treaties played in combating, in fighting, or limiting fragmentation between investment law on the one hand and other fields of public international law on the other hand?
Thank you, Lucy. And first of all, thank you for the ANU for inviting me to join this very knowledgeable panel, and I'm very happy to share your thought with you today. So as to your questions, I have studied the study from the ILC on the fragmentation of international law. Of course, there is one. There is fragmentation between investment law and international other international law for trade law, WTO law, or human rights law, or other kind of thing. And at the same time, there is also fragmentation between among the IIA themselves. You know, let's take, for example, for Thailand, we have 40 IIA in force today, and we have this party to the agreement up to four, like for Thailand and our ASEAN member states. We have like up to 4 treaties, IIAs, you know, or bids, you know, together. So there is also the fragmentation among the bilateral investment treaty themselves as well. And of course, we look at all these decisions that has been accumulated at the appendix of the book, and also other cases. Yes, there is the help with the VCLT, because every decision in that, the question of interpretation or other principle in the Vienna Convention has always been, you know, taken up either by arbitrator themselves or by the counselor of either part of the parties. Because the first question when we have the dispute, there would be the question of jurisdiction, whether this ad hoc tribunal or even institutional tribunal will have jurisdiction over this. So we are quite arguing on the questions that whether this dispute has fall under the treaty or not. So VCLT has been helpful in addressing these issues for the tribunals themselves as well. But I'm not so sure whether they solve all the problems that are there, because the way that arbitrators in these cases bring up or make their argument into these questions of jurisdictions, for example, they're not applying in the sequencing of the right sequence or the same sequence that they have. Of course, they will look at the wording of the treaty and apply 31 for ordinary meaning of the treaty. But after that, they use it, you know, in different way and in different sequence. So I think it's helpful, but still fragmentation is still there, you know, for investment treaty.
Well, I can say from experience that in a few investor state arbitration awards of which I'm aware that involved extensive treaty interpretation, and the tribunals failed to mention the Vienna Convention on Law of the Treaties, most likely because the parties did not argue them. Does that prompt you to think that tribunals may have more of not an obligation, but it would be a good thing if tribunals would use the Vienna Convention on Law of Treaties, even if the parties don't bring it up, and not just to interpret the treaty before them, but to think, as I think James Crawford, the late James Crawford would have said, to think more about bringing in, using the Vienna Convention to talk about coherence or integration between the relevant treaty and other areas of international law. Should arbitrators do more with the Vienna Convention to combat fragmentation is my question.
Absolutely. I think you are right that arbitrators will not obliged to apply Vienna Convention, because if you look at the old-fashioned old generations investment treaty, you will find that we allow discretion for these arbitrators. Some of the old treaty that we have not even mention how are they going to address the question that the dispute at their hands. So it's up to their discretion. So I think in most cases, it's the counsel of the party that's bringing that up. that's why when we look at the new generation IIA, we found that if we leave this to discretion of the arbitrators, then the interpretation of certain things will expand of their coverage or even, narrow down, and there is no consistency in applying that. So what we try to do is that try to make it clear in the treaty. So new generation treaty will address this question by saying in their provision that arbitrators have to look at the application of international law treaty that are enforced. We adopt some of the ICJ rules, into some of the treaty as well. And more than that, we try to clarify certain terms that are not always very vague, like what is fair equitable treatment. We even annex, the description of this, what is mean by fair equitable treatment, what does it mean by expropriation or creeping expropriation. We even include that if we have the problem of compulsory licensing, whether that we include in the we'll consider to be investment disputes or not. And we even put in some exemption, or exception to general exemption from that we import from the WTO into the treaty as well. So I think that is the evidence that if we leave this to the discretion of the, we need to help an arbitrator to find a way to apply the rules according to our intention. Thank you.
The states are certainly doing a lot more, not always welcome, that's for sure. But let me move to you, Professor Murphy. Thank you for being on time despite just getting off a plane. And I want to talk to you about, or ask you about, temporal issues, because you've recently written, I understand, an ICSID review article on temporal issues relating to investment treaty dispute resolution. And this is covered in the book. I'm told that chapter 12 by Agnes Rydberg and Magosha Fitzmaurice engage with temporal issues of investment treaties, including especially provisional entry into force, which is always tough. So in your view, have the rules of the VCLT performed so far a useful function in investment disputes on the resolution of temporal issues, or do you see that the tribunals refer to other legal resources when they face temporal issues, for example, the articles on state responsibility, subsequent ILC work on provisional application, or specific rules within different treaties themselves? What's going on in that Wild West?
Well, first of all, like others, let me say thank you to Esmé and Kiran for the invitation, and the Australian National University. It really is a great pleasure to be here. And like others, I want to commend the book. It's fantastic. It's well worth buying and reading, and it's going to have a long life, a long shelf life, I think, because of the various topics it discusses that really are pertinent to investor state arbitration, but also I think more just broadly our understanding of how the VCLT works. Thanks to you, Lucy, for the kind introduction and also for moderating. It's great to have you here with us. I have to say, I feel like the old man at the party, being the former ILC guy who's passing the torch to these three amazing new members of the ILC. I just wish them luck with everything they're doing. I know they're going to do a terrific job of it. If I can, before I answer your question, let me just pick up on one prior point you asked to Martins, the question of would a permanent, sort of investment court have a broader effect on the field of international law. One interesting analog we could be thinking about is the Iran-US Claims Tribunal, which, not only has a quasi-permanent status, is beginning to feel like it's a permanent status, but through the 80s, early 90s, as you particularly, Lucy, know, having been an agent to the tribunal and me as a successor of yours, it handled a lot of investment cases, and it's pretty clear when you look at instruments like the Articles on State Responsibility that you mentioned, that the Iran-US Claims Tribunal jurisprudence is being cited left and right by the ILC on issues of attribution, on issues of reparation. It was a font of information that extended well beyond jurisprudence, that extended well beyond the confines of the cases. It was the type of cases it was dealing with. So that might be an indication of what perhaps a permanent court would look like. But to your question, temporal issues. So one observation is that there's a temporal aspect to the VCLT itself, right? There's an Article 4 on non-retroactivity, and to the extent that we might want to push investment tribunals to, talk about the VCLT, I actually think they need to be pushed even further to ask the question, does the VCLT apply to the treaty before them? Because if it's a pre-1969 treaty, it clearly doesn't apply. But even if it's after that, the question is, when did the BIT, or whatever the treaty is that's in play, when did it enter into force for the two parties before the tribunal? Because it's only after that date that the VCLT has entered into force for them that, strictly speaking, it applies. Now, you can, of course, then go to the next analysis of its reflecting rules of customary international law and all that, but it's a further dimension that probably should be addressed in some fashion. There are some rules within the VCLT that may well not be customary international law, and even if the two parties before you are saying that they are, I think you need to do the broader analysis of whether it actually, fits the type of widespread practice that we look for in customary international law. But I think your question really was more to things like Article 28 of the VCLT, and I agree with you. The chapter in the book is really great on this. And VCLT Article 28, just to remind everybody, is the idea that unless there's a different intention expressed in a treaty, its provisions do not bind the party in relation to any act or fact that took place or any situation that ceased to exist before the date of the entry into force of the treaty with respect to those parties. So that certainly introduces the element of, let's say it's a BIT, the bilateral investment treaty enters into force. It's not supposed to be regulating things, acts, and facts that predate it. There is a connection, as you said, to the Articles on State Responsibility. We've got Article 12 of those articles that says a breach is only going to occur when a state acts in nonconformity with an international obligation. It does say regardless of origin, so that can include a treaty, but it can include other sources. And then it goes on in Article 13 to say an act of the state does not constitute a breach of an international obligation unless the state is bound by that obligation in question at the time the act occurs. In my mind, both of those Articles on State Responsibility, 12 and 13, reinforce the VCLT Article 28 proposition. So what I see in investor state tribunals that approach this issue is they are starting with Article 28, and then they're often using Articles 12 and 13 of the Articles on State Responsibility as a sort of a reinforcement element to it. And part of the reason for that is, of course, in the VCLT, Article 31, paragraph 3C, on how you interpret a treaty, and I know we'll probably talk more about this, but that Article 31, 3C provides that when interpreting a treaty provision, it says take into account any relevant rules of international law applicable in the relations between the parties. So the VCLT itself is saying, when you interpret, pay attention to things like the Articles on State Responsibility. Let me just finish by saying, yeah, there's lots of cases where this is coming up, and I won't even get into provisional application of treaties because that's another whole thing, but just issues like if a violation occurs before the BIT enters into force, and then you bring the dispute after the BIT enters into force, can you put that violation before a tribunal? If the violation is of the BIT, the answer seems to be no, because the BIT wasn't enforced. But what if the violation is of something else? Customary international law, a national investment law, maybe a predecessor bit to the later in time bit, right? So you'd be using the dispute resolution provision of the new bit, and you brought the dispute after it entered into force, but it relates to something before that. It raises very interesting issues that you need to dig into the VCLT and its travaux and also the articles on state responsibility to answer those kinds of questions.
Thank you. And as we know, it's 17 years of travaux, so it's a challenge. Do any of the panelists want to comment on any of the points that the others have made in this conversation on the influence of VCLT on investor states? I see Vilawan looking ready. Go ahead.
Just to pick up on the last point that Professor John Murphy was telling. In the case, in one of the Thai case, there is two treaties that coexist. That's in the opinion of the tribunal, is that the first treaty allow only for state dispute settlement, and the second treaties allow for investor state dispute settlement. And other than that, in the substantive provision, in the second treaty covered fair and equitable treatment and expropriation, where the first treaty doesn't have. But so what's happened is that what arbitrator in that case has been doing is that is apply, because the new treaty only said that investment, any investment that it doesn't say when the investment before this treaty or in the old treaty. So arbitrator was interpreted according to 31 VCLT. That's ordinary meaning. It doesn't allow arbitrator to interpret otherwise, because investment is investment, is not that investment at this time or that time. And it's go on to say that then this treaty coexists. So it depends, whether you will take the dispute, followed by on the basis of the older treaty or the new treaty. And in this case, investor has brought the case under this new treaty. I'll finish up that is that, and again, but in terms of damages, arbitrator rules that damages will not cover the damage that happened before the time of the new treaty, entry into full force of the new treaty. So I think they are applying the conflicting rules of temporal, as is mentioned. That's what's happened in the case. I just want to point out that it's a real case.
Thank you. There are a lot of variations on that. Seeing no other hands, let me sum up in a sentence or two sentences. There is an influence of the Vienna Convention on the Law of Treaties on ISDS, investor state dispute resolution, although there could be more. It could be more orderly, more controlled, maybe will be as we move forward. And because I want to talk about moving forward, let's jump to reform in investor state dispute settlement, which is very much front burner right now, following what's happening with ICSID, UNCITRAL, etc. Martins, I told you we would come back to UNCITRAL Working Group 3, and I am with you with the first question. Obviously, it's the UN General Assembly that exercises its powers to set up bodies other than the ILC to assist in codifying and developing international law. And another Exhibit A is UNCITRAL Working Group 3, which is having very extensive meetings right now. I would say they're neck deep, if not drowning, in possible reforms in investor state arbitration. So my question may not be intuitive. Does the ILC, where you all serve or have served, stand separate and apart? Or there are things that groups like UNCITRAL Working Group 3 could, which is much bigger, could learn from the ILC's working methods, and vice versa.
Thank you, Lucy. That is a great question, I suppose, whether the twain of Vienna, New York, and Geneva, in whichever town one puts ILC properly, can ever meet. And I think it's very interesting that ILC and UNCITRAL might be looking in some ways at things that are not dissimilar, but it is quite likely that for most countries, there would be different people who speak in the Sixth Committee or who speak in Vienna. Not all. I know that indeed some of my former students are working in both capacities, but overall, I think that there is, anthropologically speaking, a bit of a mismatch between the Sixth Committee and UNCITRAL group. I think as a general matter, my instinct about institutions that it is important to learn from each other, but it does not necessarily mean adopting the same approaches. We also have to be respectful of the genuine institutional differences, which might suggest that we are learning, but learning in the sense of how not to do something because the important key functional factor is different. And just as an example from a different setting, one of the hats I wear that you mentioned in your very kind introduction is a member of the implementation committee of the Water Convention under UNEC, which is one of the multilateral environmental agreements. And there are a couple of them in that setting. Probably Aarhus Convention would be the one that is most globally known. In some of those settings, we are independent experts, as I am. In other settings, other committees, representatives are of states. And it is a very interesting question how that shapes the dynamic and assumptions of the functions they are exercised. And I think that is a key important difference, a very obvious one, but still worth spelling out between the ILC and the UNCITRAL working group. If anything, as I think participants in this panel will know much better than I do, there has been some pushback by states precisely on the point, on the sense that representatives within the UNCITRAL working group and UNCITRAL more generally might be too independent, too, as it were, independent-minded from the broader public good promoted by states. So I think probably truth is somewhere in the middle. They are different, but can learn from each other. I think, so probably it seems to me that there are three constituencies that are important. There are the independent or independent-ish experts, states, and secretariats. Secretariats, I think, in any institutional setting are extraordinarily important and do extraordinarily important work. And I think I have found the work done both within the ILC as well as within UNCITRAL very helpful and illuminating. The notes prepared in UNCITRAL, the Secretariat reports prepared in the ILC are in many ways to-go-to guides on important questions. I think there may be perhaps somewhat more scope from the UNCITRAL side to borrow from certain things within the Sixth Committee setting, because I feel that if I want to know in fairly fine detail, we spoke about the State Department as an example, what State Department has thought on a particular issue on state responsibility or on law of treaties over the last few years, it is fairly easy to find one's way around ultimately to fairly detailed pages-long submissions. While within UNCITRAL setting, there are certain written submissions that are freely available, but possibly others less so. So I think perhaps greater openness towards the content of the submissions, something that is so helpful in the Sixth Committee setting, could be helpful. Ultimately, and I think these are things that will be my last point, and this is something that is hard to pin down. I think a question about the extent to which institutional fixes and tweaks can channel consensus, or the extent to which disagreement reflects genuine fundamental policy differences that are going to be there through whatever technical means they are articulated. That, I think, is a real question in many of these settings, and of course characterization of an issue is on its part, a way of how argument is presented. But that is, I think, something that makes it even more complicated to assess the borrowing. So I think my short answer is absolutely learning, but that does not necessarily mean replicating. Thank you.
Thank you. Sean, Martins mentioned formats indirectly, and I've never been on ILC, but I know that the ILC grapples with the form of work outputs. It used to always be draft articles with an eye towards being put into conventions, but now there are more alternative instruments, guidelines and conclusions and studies. So my question is a variation to you is, do you think that groups like UNCITRAL Working Group 3 might learn from the ILC's evolution into different types of output for the public?
Yeah, I mean, maybe. Certainly you're right that the ILC has, traditionally been focused mostly on draft articles that could lead to a convention adopted by states. And yet it's harder and harder to get conventions adopted these days. And so the ILC has gravitated a bit more towards other kinds of products, conclusions, principles, guide to practice, reports, even just a sort of survey and study of an area. The ILC typically has to confront two main issues when it thinks about this issue. One is what do we want to call the product? Because the name seems to signal something to people. And then the second is, what are we going to recommend be done with said product? So the relevant factors that go into those decisions, which are linked to an extent, is, do you think you need a legally binding instrument? There are certain things you just can't do without a treaty. I did a project on crimes against humanity. Part of it deals with things like extradition and mutual legal assistance. You can't do that unless you actually have a treaty in place. So an issue around UNCITRAL is, in terms of what we're doing, does it need to be something that's legally binding? If so, there's a couple of different paths. One is convention. Another is more in the nature of model rules that would be adopted as national laws in some way, right? And so there's different paths there, but a different possibility is that you're not trying to create new law. You think you're instead really codifying an existing practice of some kind. And if that's what's going on, then you could go down the path of something else, conclusions, and so on. Principles, maybe, there's more abstract and less abstract things you could do in that regard. But there is a risk there. And the risk is part of what you were, and I think Martins too, were kind of getting at. If you are attempting to pretend like you're codifying existing law when in fact you're doing something more than that, then it calls into question your basic legitimacy. You're not a legislator for the world, and if you're portraying yourself in that way, that's a path to perdition.
Fair point, and there are battles with all the observers at UNCITRAL Working Group 3, and we've already referenced the battle between private investors and states, but helpful answers. I'm going to turn to you, Penny. Last year, I understand you spoke at an event discussing the role of the ILC in providing stability through international law and addressing change by providing states with, I think the word was tools, to respond to new issues, to new challenges. So would you say that this theme of stability, change rings true for the ILC's work on the VCLT itself? Let me put that another way. Are there provisions in the VCLT that perform this function of stabilizing for areas like, newer areas like investment law and investment disputes?
So thank you very much, Lucy. before going on to that second part of the question, as I see it, there's an ongoing tension internationally today between the need for stability in international legal rules applicable to all, and the demands of today's very fast-changing world and international environment. So the ILC, as everyone knows, is a mandate of the codification and progressive development of international law. The codification part of it includes through the development of treaties and helps to provide stability. And it does this by providing the framework for the development of legal rules. And I completely take Sean's point about the need for the ILC not to be seen as a legislator, that it is states that take forward the products of the ILC. But the second aspect of its work is the progressive development of international law. And this is the terms that I use. I say that the ILC can assist in providing states with the tools necessary to respond to new and emerging issues. And it does this through using international legal principles as the framework to address new issues. So returning to the VCLT, I see that the VCLT is a microcosm of these two mutually reinforcing influences. So I think that the theme of stability and change is as relevant to the VCLT as it is to the ILC. And first, the Vienna Convention provides stability through its codification of the rules on treaties. This is one of the words used by the Ashrita Ambast and Dirk Pavlovsky in the book, where they say that VCLT has exerted a unifying force for treaty practice in international investment protection and promotion. So that is the stability aspect of it. And I agree with this. And I also consider that Article 31 especially provides that stability. And it does this through the very clear explanation of the interpretation of IIAs that, as we all know, give the ordinary meaning to be given to the terms of the treaty in their context in light of the object and purpose. And that's become the mantra for IIA interpretations. However, this does not necessarily mean that there's stability in the application by tribunals of IIAs. And this has been identified as in some of the chapters of the book and has been identified as being one of the issues. But I set that aside. So returning to the theme of stability and change, the VCLT has within it the framework for addressing a range of different types of treaties and different types of issues that might arise. I see that it has the potential for being a blueprint for addressing some of the new issues that are arising, particularly the issues arising from the move from the old style BITs towards the new style IIAs that Vilawan talked about, and for addressing potentially some of the reform proposals. Some of the issues, such as Article 30 on the success of treaties and Article 59 on the implied termination by conclusion of a later treaty, I think particularly important here. But there's also other provisions as well on termination and suspension of treaties. And they include, for example, Article 54 on the termination of a treaty under its provisions or with the consent of the parties. And Article 41 as well can provide an avenue for the implementation of reform efforts, as it did through the Mauritius Transparency Convention. But there's room, it seems to me, for more guidance to be given to tribunals by states and how they might use the Vienna Convention rules. And I return back to what Vilawan was saying regarding the sort of not only interpretive notes, joint interpretive notes, but also explaining in annexes what the meaning of particular provisions are. So there may be a role then for states to give greater guidance to arbitral tribunals and how they go about ensuring that the reform proposals are actually followed by the tribunals in fact. So it seems to me that when designing the ISDS reform proposals, the states need to pay very close attention to the various provisions of the Vienna Convention on Law of Treaties, which can facilitate this. So I will stop there. Thank you.
Thank you. I agree that if such guidance were linked to the Vienna Convention, some of the more renegade tribunals might follow the guidance better. But let me ask one last question on this to Ambassador Vilawan. It's a broad question, although I expect the answer may not be that long. Overall, what role could or should the ILC play going forward to contribute to the development of international investment treaty law and treaty-based arbitrations? Sort of some tick points or checkpoints you could give us.
Thank you very much. ILC has already done some work, on investment, economic law, and that's MFN, and even study on the FET, and it's stay on the long-term project of the ILC for a long time. So I hope to see that ILC will continue doing the work on these issues, because it's evidenced by more than 3,000 IIAs that has been concluded, today, and also cases that you can see from the appendix, that there is enough cases that on various issues that ILC can think of, codify, or even put this into writing. It can done it as a comprehensive, I don't know, or even piece of piece by piece. But I think it's very important that, as John Murphy was saying before, that it is the state itself. So I think the state member state of UN need to make clear that in agreement, whether they are in agreement that they need this kind of provision or not, and this kind of law or regulation to help them. I see that there is a need there, but I don't know that whether there is a political, will to pursue that need. Thank you.
Thank you. Thank you. Are there any comments from any panelists intra-panel right now and points that have been made in the last round? Sean.
Maybe just make one quick point, which is that one of the things the ILC ran into when it did the second MFN study was a strong appreciation that a lot of the bilateral investment issues are embedded in bilateral treaties, right? So, and the treaties use different language, and obviously there's different intentions of the parties. So one risk here is when you try to do broad general rules of some kind, you need to do it in a way that's respectful of the fact that a lot of these instruments have different meanings and are written in different ways. It just poses a difficulty.
And not always purposefully, but the differences are there. We have two questions. Let's look at the two questions right now so we don't run out of time. The first comes from the Thai MFA, and the question is this: does the panel think that there are any aspects of the VCLT that are inadequate, unsuitable, too archaic from 1965 in dealing with more recent investment law? I open that up to any and all of you. Having been born before 1965, I hesitate to say it's archaic, but we have moved on. Sean.
Well, I'll take a crack at it, but I'm happy to just riff while others are pondering it. It's a great question. It's a really interesting question. Maybe an even book could be written about this. I will say just this, that when it was done in 1969, I think the VCLT only went so far. It left a lot of things on the table. So we mentioned provisional application of treaties. It's a single article, right, with a couple really short paragraphs, but it's a big issue. So, I think that's why the ILC embarked on an entire project where it did a guide to practice on provisional application of treaties. Likewise, we mentioned subsequent agreements, subsequent practice. That's a big issue. And there's only a couple paragraphs on that in the VCLT. So the ILC took that up. Reservations, same thing. ILC did a huge project on that. So it certainly did not cover all the bases. And therefore was worth revisiting and deepening. But right off the bat, at least, I can't think of anything that's like bad about it. I think they did a pretty good job.
Martins, any thoughts? Yes.
Right. I was hoping that I might provoke an interesting discussion, but unsurprisingly, I'm mostly on the same page with Sean. There were some limited cases that Vienna Convention did not cover in terms of scope, but ILC, of course, looked at armed conflicts and treaties as well. And that has, I think, within the broader balance, I think, of the Vienna Convention model has been fairly favorably received. I mean, to some extent, I think it's really the genius of the ILC and the Vienna Conference of framing law of treaties as an agnostic instrument that might be doing good things or bad things, completely agnostic on the content, just as in a later project, it was on state responsibility and primary obligations, very open on most aspects regarding opting out from default rules. I mean, I think that there is an interesting question to consider whether there are certain, I think, procedural elements of the of the investment arbitration, in particular, the way how the lawmakers are divorced from the disputing parties, which is perhaps to some extent, not completely. Vienna Conference was not anachronistic. They knew what human rights were. Aaron Bruches was sloshing around and speaking about exit, so they knew about stuff. But I mean, still, it does raise somewhat interesting questions, sort of the high C sort of questions. What happens if the investor might not have known of a legally relevant Article 32 material? I mean, it is one of those interesting puzzles. I mean, the majority must be right that treaties content cannot be flicking and changing depending on who the claimant is. But Judge Brouwer must also be right that it's a bit naughty to invite the investor to invest and then defeat them with a secret preparatory material. So I think that there are some things around the edges, but my inclination would be to think that they are best answered by drawing on the general, overall very wise principles of the Vienna Convention itself. So I would probably end up in the same place. Fantastic framework, very much deepened by state practice, but that is also, I suppose, showing the strength rather than the weakness, that is a benchmark and framework with which states are comfortable with working rather than working against.
Fair enough. Penny, please.
Yeah, thank you. And I agree that's a very interesting question. I also, not surprisingly, agree with both Sean and Martins about the value of the Vienna Convention and the value of the ILC's work in expanding on particular provisions of the Vienna Convention. There was one, I would not say it's archaic, but there was one area, and that deals with third-party rights in Articles 34 to 38 of the Vienna Convention. So in 1969, of course, it was very much a state-centric approach to the law of treaties. And now international law is moving more towards the conflagration of different treaty regimes with different parties and much more of a nexus between various state parties, but also the growing relevance of non-state actors and the whole potential issue or question as to whether third-party rights under the Vienna Convention extend not only to states, but to investors. And I think this is actually quite a controversial issue, but I know that some tribunals have taken it or taken it to the extent of suggesting that, yes, investors do have third-party rights in accordance with the Vienna Convention. So That is an area where potentially it's a bit of a mismatch between the Vienna Convention and sort of current international legal practices. But I wouldn't say it's necessarily archaic, but something that's worth reflecting on in future. Thank you.
Thank you. I think it's safe to predict that there will be no amendments to the Vienna Convention on the Law of Treaty or rewriting. We have that to rely upon. And I'll make a plug here for the book to say that even though this was an unexpected question, many of the chapters in the book touch upon this spotlighting, if you will, on different aspects of the Vienna Convention, dating from the 1960s to how they're being used with investment law today, which makes it, as Sean said, a very useful read for many of us. There's another question that's directed to Martins, so I'll ask for a short answer, but I'll read it out loud for the audience. Please elaborate on what you alluded to in relation to the terminology of case law. Is this because judicial decisions in public international law are not law themselves, of course, but only stating, finding, confirming law? Is the term jurisprudence, as another term, a better term to use? And are there issues in relation to the degree of authority sometimes attributed to, for example, ICJ rulings? I'll let you maybe refrain or reorder that question before you answer it.
Thank you. And I mean, I have to say that this is one of those wonderful questions where there's a question and there's also the answer, with which I almost entirely agree. I mean, I think sort of perhaps it comes naturally in following my sense of what makes investment arbitration so peculiar, interesting. It is a thing that it lacks rather than thing that it has. So the only unifying element is the generalist vocabulary. So I think I have increasingly felt that being fairly strict in thinking through the rules on sources, interpretation, responsibility, particularly because it is so hard to gather consensus in a consistent manner across all the decentralized fields is important. And case law, no matter how much one tries to dehydrate that from the domestic legal baggage, I think is impossible. And I think the question makes the absolutely correct point within the Article 38, paragraph 1 framework. Judicial decisions state the law, as the question says, hopefully correctly, but ultimately, and I think that this is one of the things from the last quinquennium that I have probably quoted most, commentary to conclusion 13 from the customary law conclusions, the idea that judicial decisions are neither, as it were, dispositive nor irrelevant. There are multiple considerations that we take into account: quality of reasoning, character of institution, and ultimately reception by states, other tribunals, and scholars. And so I think if we think about the International Court of Justice, in many cases, although not invariably, those considerations would point in one direction. If we think about investment arbitration, where the quality and reception might be a bit flimsier, we might be going another direction. But that, I think, is a point. International law already comes with a very sophisticated apparatus, an analytical framework for evaluating the relative weight of decisions. I don't think that going back to the slightly sterile debate of whether we have case law precedents adds, I think it subtracts. So it could be jurisprudence constant. I think that is something that James Crawford, who was mentioned before, seemed quite comfortable with. Perhaps a slightly more civilian one, or indeed not inventing anything. Subsidiary means as judicial decisions. If it was good enough for the Advisory Commission of Jurists, perhaps we can just stick with that.
Thank you. We have about a little more than 15 minutes left, and I have one last group of questions. One for each of you, final reflections, if you will. And as background, we all should recall that the whole aim of the ILC for the Vienna Convention on the Law of Treaties was to draft the general law on treaties that would apply regardless of the field or regardless of the subject. And this is addressed in chapter 20 of the book, already mentioned by Ashwita Ambast and Dick Polkowski, where they consider the extent to which the VCLT acts as a unifying force or not for investment treaties. We've touched on this, including their exploration of how states sometimes have adopted specific rules in BITs that depart from the VCLT, even by including specific rules on interpretation of investment treaties in those treaties themselves. But I'm sorry, let me back up. The UNCITRAL Working Group 3 considered specific rules on interpretation for investment treaties. I misled you, but they decided not to go there, at least not yet. So first I'll go to Sean. To the extent particular approaches could or should be developed for, I would say, specific approaches within treaties, is that a role for states, individual states, or would it be best if it's multilateral? In other words, if we cross this border into having sort of a sub-bit of rules out of the Vienna Convention for investment treaties, who should do it?
Yeah, well, maybe I'll just clarify one thing, which is I think the VCLT, when you step back from it, is doing two very different things. One is it's telling us how you get into a treaty relationship. And I think that front end of the life of a treaty, how does it get ratified? Can there be reservations, things like that? I don't see how that gets changed. That's critical before you can say there's a treaty that binds these two states. Once you get past that, though, and you talk about the operation of the treaty, whether it's interpretation, whether it's pacta sunt servanda, whatever, or exit from the treaty. What is interesting about the VCLT is it is clearly secondary rules, and it repeatedly says, unless the parties decide otherwise, here's the rule. So it's an invitation to, contractual freedom for the parties if they wish to do something different, including on something like interpretation of the treaty. It's perfectly fine if you want to construct your own rules. If you were trying to do this for the entire field of investment, I think you would have to have a multilateral treaty of some sort that everybody's bound to. I don't see how you can do it, at least, with any consistency in a different way. But I don't know as you need to either. I think if two states wish to depart, I'll just return to my retroactivity thing. There's ways of interpreting what the VCLT means and maybe the articles on state responsibility, but you can contract around that if you want to. That's fine. The problem is states aren't often doing that, right? They're not really thinking through these issues and saying, here's what we really want, or they're not clearly expressing it, that kind of a thing. But yeah, that's my big takeaway. Yeah, contracting out is fine. But if you're going to do it on a sort of systemic level, it probably needs to be a multilateral treaty.
Fair enough. And we'll see what UNCITRAL Working Group does or doesn't do in this area. Let me go back to you, Martins. Do you think the Vienna Convention on the Law of Treaties will continue to endure as the general law of treaties, or be, I don't want to say eclipsed, but be accompanied by more specific approaches that are needed? And if so, what topics can you envision where such approaches would work for investment law?
That is an excellent question. I think perhaps in the same vein as Sean, because of the great flexibility of the Vienna Convention, except for a few, I suppose, almost natural law aspects that we have to buy in, shall we say, intrinsic, or perhaps too early, like pacta sunt servanda. If we don't have that, we don't speak about law of treaties at all. So it's hard to think of contracting out of it. Or perhaps certain elements regarding peremptory rules, but I think that really neither of those play an incredible amount here. I think my inclination would be to say that Vienna Convention would still provide the generalist vocabulary. Whether it would also provide answers to all the questions is a different point. Because of the great flexibility, there are probably almost everything that one can get to. And I think that was, I was looking through the answer to our working group materials a few days ago, and there were opinions on treaty interpretation by a number of scholars, and Jan Kluwer had a very nice, short and slightly polemic piece where he was saying, well, law of treaties is essentially political. It will not stand in the, as it were, it will not confront political will. There may be various technical means of getting there, but ultimately there will be few things that in the presence of genuine political consensus, Vienna Convention would prohibit. And that strikes me as sound. I think, if anything, that there are certain aspects where there may be Vienna Convention be even too influential. I mean, one of my bugbears recently has been application, not in the sense of Article 30, but in the sense of application in the process, and whether some things that we are sometimes discussing as interpretation, particularly regarding certain vaguer rules like fair and equitable treatment, are actually instances of application. And we are doing violence with the fabric of Vienna Convention by trying to characterize them and explain them through Article 31. But if anything, again, that is an example of success of Vienna Convention. It is so good that it is being invoked even to apply to things where it should not be applied. So again, an excessive success story of sorts, but still a success story.
Thank you. When you said this is how misunderstandings occur, when you talked about Prof. Jan Kluwer, I thought you were saying for a second, young clubbers like to talk about the Vienna Convention. And I thought this would be, this would be not okay. More seriously, well, speaking of young clubbers, not necessarily clubbers, but with my students, I have to admit that I pretty much stop with the treaty interpretation parts of the Vienna Convention, Article 31, 32, etc. But one thing I like about the book, Ambassador Vilawan, is that the authors highlight the importance of the Vienna Convention for investor-state disputes that go beyond the what you could call the billboard pure treaty interpretation articles, which are just a handful. So if I may ask you, what, I don't know, theme or rule or approach do you think is the most important contribution made by the Vienna Convention on the Law of Treaties to investment law? Is it treaty interpretation or other things?
Yeah, I think mainly it's a treaty interpretation, because as we know that the language of the bilateral investment treaty and IIA that we are having is very vague, and it's developed over time as well. Is that changing in the new treaty, in the new bit. So I think it's helped to provide the party what is the real intention of the party to the treaty. But don't forget that investment treaty is not a contract. So it's not investment treaty draft by us, by foreign affairs, by people in the government, but the people who use it is the private sector and also the government. So that's where the dispute happen. So I think it's not safe to say that it's a party intention that they're going to be drafting the treaty like this. That's why it's not perfect for the bilateral investment treaty in itself. That's why the role of the VCLT is very important. I mean, it's very great, at the moment, because there are vagueness, there are ambiguity in the treaty, and there are unfairness, maybe in a certain extent of the treaty, of bilateral investment treaty. That's why we seek the justice from the VCLT. So I think at the end of the day, we might need to have a comprehensive multilateral investment treaty sometime, I don't know when, but in the future.
That's an aspiration for sure. A follow-on question to you, Penny. Throughout the book, there are also references to certain rules in the VCLT that have been underutilized, that could have been utilized in investment disputes. As we see this field continuing to mature, can you identify any particular rules in the Vienna Convention that are likely to or should become more influential in the field?
So thank you, Lucy. I want to make a preliminary point, which kind of tries to draw together what we've been talking about. I very much agree with those who say that international investment arbitration is at a crossroads. And the UNCITRAL Working Group 3 is looking at the reform proposals and how it can be improved in future.
Did you say you do or you don't agree?
I do agree. Did I say I don't agree?
No, I just wanted to make sure I heard it right.
No, I do agree. So states in this process are trying to rebalance power among themselves and between host states and investors. And part of this rebalancing is to reinforce the right to regulate and to advance new or revised economic or policy goals, particularly cooperation rather than just simply promotion of investments. So in these circumstances, the states are trying to reinforce their state sovereignty and party autonomy and to conclude various alternative treaty arrangements. So this might aspirationally be a multilateral investment treaty, or it may be an alternative, but also, as Sean said, there's more likely to be individual parties, states seeking to rebalance their own agreements and also terminate and then enter into new treaties. So it seems to me, coming to the question as to what provisions of the VCLT may become more important in this atmosphere in the future. Although the VCLT provides the general provisions for treaties, but also particularly I agree with Vilawan that Article 31 is one of the most important provisions. One of the ones which are not used so frequently, and this will come as no surprise to those who have been listening to this webinar, is Articles 30 and 59, to my mind, which Shani Friedman in her chapter in the book have identified this as being an issue, and I agree with much of what Shani says in that book, in that chapter. But second, there is the whole issue of subsequent agreements and subsequent practice. So we have now the ILC's work in this area, which is substantial and excellent. And I think it's important not only to draw on that work should be drawn on by arbitral tribunals, but also it should be drawn on by states to develop joint interpretations and joint statements to reinforce their views on the interpretation of the bits that they entered into, or the IAs that they entered into. And I come to the point that who are the masters of bit interpretation? And so this is a very relevant question to ask. And it was asked in the book, and I think it's a very good question. And I think it's important that that there be a clear answer to that and be acknowledgement as to what is the answer to that question. So just to conclude, the Vienna Convention sets out the rules for the interpretation of treaties, and I think that within them, there is sufficient flexibility to be able to address the reform challenges that are coming. And I come back to what I've said before, it's not just a question of interpretation, but the application of the interpretation to the facts. And that will continue to make not only the role of the arbitrators essential for the resolution of particular factual disputes, but also it will continue to pose some very interesting issues for international investment scholars in the future. So thank you.
Thank you, Penny. That's a very good answer for coming to a necessary conclusion to the webinar. We could have a whole, well, I think all of us could spend whole days talking about Shani Friedman's chapter on Articles 30 and 59 and ACMEA, the intra-EU material. We could spend a whole day more. ILC could spend a lot more time on how to use Article 31 and then with guidance on how to apply it. There are many questions we didn't get to today, but we do have to come to a close. And I feel I have to make one more admission, which is that most of the questions I asked came from Esmé and Kiran. They were excellent questions and guided us through quite a good discussion. So before I turn it back over to Kiran and Esmé, I want to thank you for helping us get organized and helping me to elicit such good commentary, some of which was unexpected, some of which was expected from our wonderful panelists. Thank you.
Thank you so much, Lucy, for leading us through this conversation. For those of you who don't know me, my name is Kiran Nasir Gore, and together with Esmé, I've co-edited the book, Vienna Convention on the Law of Treaties and Investor-State Disputes, History, Evolution, and Future. We welcome you engaging further with the book, which our panelists are very, I didn't pay them to hold it up at the moment, but they're all holding it up at the moment. I welcome your further engagement with the book. There are a great many topics that could be engaged, and Esmé and I have done a great bit of work to line up some of the questions, but I think there are more answers and issues to be explored, and we've been really grateful to have Lucy and our panelists guide us through some of their insights from their unique vantage points. We've also explored some of these topics in a recent symposium that we organized under the Cambridge International Law Journal's blog. And there was a link earlier in the chat to that, where our focus was specifically on the ILC's contribution vis-a-vis the VCLT and also to investment law, in particular commemorating the 75th anniversary of the ILC statute, which took place in November of last year. Thank you not only to our speakers and panelists, but also to you, our audience. You had some great questions, which were great fodder for food for thought, and also to our hosts, Australian National University College of Law and GW Law School, who are not only our hosts for this evening, but also the host to Esmé and my academic work and our teaching work. So we're especially grateful to have their support in all facets of our lives. With that, I think I will conclude and wish everyone a good morning, evening, and night. And thank you again for your engagement.